Okay, welcome everyone to another informative webinar on a topic most take for granted. You say things like you'll get to it, or my kids will take care of this, or I'm not old enough, etc. There's a lot of reasons and so on, right? Well, I am Peggy West. I'm the webinar organizer, and I want to thank you all today for joining us and getting involved in this important topic. Before we get started, let me cover some housekeeping. If you have a question, put it into the Q&A box. And if you have a comment, just put it into the chat box. So we are being recorded today. I just want to let you know that all of the questions in the Q&A will be answered at the end of the webinar, and our moderator will help with that. So let's get started. Today we have Dalia, Anise. She's an attorney. She's going to share stories and facts about what we all need to know on wills, trust, and incapacity planning. First, I want to start by introducing the moderator, Daniel Baum. He's the founder and CEO of COA Solutions, insurance broker. So Daniel, I'm going to let you take it from here.
Perfect. Thank you so much, Peggy. Hi, everyone. Happy Tuesday to you all. It is my distinct pleasure today to introduce you to Dalia Anise Esquire. Dalia is an attorney specifically in estate planning practice, focusing on guiding her clients through the often confusing maze of financial and legal decisions to create plans for families, their well-being, and their long-term family goals. Her considerable legal expertise includes family protection, wealth preservation, and value-based planning. Dalia has also been practicing law in South Florida since 2010. She's a graduate of NSU Shepherd Board College of Law in Fort Lauderdale and is licensed in both Florida and New Jersey, with the focus of her practice being in estate planning. She is a zealous advocate with the highest ethical and professional standards. Dalia has had the remarkable ability to think outside the box to find solutions to problems that many others would consider unsolvable. In addition to her law practice, Dalia is very active in her church and is mentoring middle school girls. She's the mother of 2 and grandmother of 4. Now, I'll say you will find all of Dalia's details in the chat, including a link to schedule a call with her personally. I just want to reiterate before Dalia begins her presentation that the chat is not going to be monitored throughout this presentation. It's really just there for you to have access to Dalia's contact information directly. But if you'd like to ask Dalia a question, we're going to ask that we have our Q&A session at the end of the presentation. So please put your questions in the Q&A specifically, and I'll be asking Dalia those questions for all of your benefit at the end. So thank you very much, everyone, for joining us. And with that, I will turn it over to Dalia for her presentation.
Thank you so much, Daniel, for that introduction. So hello, everyone. My name is Dalia Anise. I am an estate planning attorney with Legacy Life Plan. I'm the founder of the firm. So let me share. Let me start my presentation. Okay, and give me 1 second to do. Okay, let me. Sorry, give me 1 second. Here we go. Okay, so I want to first start out with giving you a little bit of information about myself. I know Daniel spoke a little bit about me, just to give you, my credentials, how I got here, and why I do what I do. Our presentation is going to be about wills, trusts, and incapacity planning. First, I want to share, this is my family, my husband, my children. They're both married, and I have grandchildren that are the joy of my life. So I started out in a law firm, in my husband's law firm. So my husband is an attorney. He does personal injury, and I was his his office manager for many, many years. And when my daughter was about to start college, I felt a calling to go back to school and get my law degree. So I went to Nova for law school, and it was an interesting time. It was me, my daughter, and my son in college at the same time. You can imagine during exam time how our house was very tense, and my poor husband having to deal with all of us about to take all these exams. So in law school, I interned for an estate planning attorney, and I really loved it. But graduated in 2010, and it just made sense for me to join my husband in the family practice. He had a thriving law firm with associate attorneys, and everything was going well. So it just really made sense for me to join him. And after joining him for some time, I really, I was working, but I really was not loving the work. I got a taste of estate planning while in law school, which was, I fell in love with it. And then let me share this with you. Yes, again, my grandkids. So in 2018, my aunt, who was a brilliant woman, she was a professor at Stanford, taught at NYU. In 1969, she worked for IBM as a computer programmer. And we know during that time, women did not have these amazing roles. So very powerful, very wonderful, amazing role model for me. She retired in Florida, and she got a stroke, and she became paralyzed. And she had created this estate plan where it allowed me to be her advocate, to be her agent, to be her power of attorney, to be her healthcare surrogate, so that when she became paralyzed and needed to be in a nursing home, we didn't have to go to court. Her estate plan was so well drafted that I was able to make very important decisions for her. So when I took her to the doctor, the first thing they asked me, who are you? Where are the legal documents that we can give any information to you? If she did not have that estate plan in place, we would have had to go to court. It would have been a very expensive and very difficult process to go through. So realizing this, again, I fell in love with estate planning, and because of her, I told my husband, I love you very much, but I'm going to step back from your firm and start my own firm and do this full-time, do estate planning full-time. So let's get into why you're here. Okay, so what is estate planning and the different documents that you need to put in place? So I will tell you that a lot of people think of estate planning as documents. I'm going to an attorney to create documents, but it's a lot more than that. But before I get into what this a lot more than that really means, I want to explain to you the document portion first. So let's talk about, okay, the will. What is a will? A will takes effect after you pass away, and it's just instructions of how you want your assets to pass down to your loved ones. Something that people don't realize is in order for a will to be validated, it has to go through probate, which is the courts. And wills are public records. So if you Google Jacqueline Onassis's will, if you Google it, if you go to Google and just Jacqueline Onassis's will, you will be able to read her will. It's online. So wills are public records. People can see them. And it's not like you see in the movies where you go to an attorney's office and he just distributes everything. No, the court has to first validate your will. And it can take 3 months, 6 months, sometimes years for this to happen. The next thing is a trust. A trust is an interesting vehicle, and I'm going to go into it later on, but it's not public record. It's a private vehicle that allows you to pass your assets down to your loved ones without any court intervention. And this happens, it can happen in an attorney's office, and your trustee can pass down your assets and divide your assets according to your wishes and what you and your trust. Now we have the healthcare directives and the financial power of attorney. I want to first start with the financial power of attorney. The financial power of attorney is a very powerful document that allows whoever you name to be your agent so that when you're incapacitated, they can take over, okay? They can pay your bills. They can manage all your assets without any court intervention. And again, the idea of a well-established estate plan is to avoid going to court, is to avoid having a judge who doesn't know who you are, doesn't know what you want, to intervene and make all these important decisions for your family, and your family may not have a say. Okay, whatever the judge says is gonna go. Healthcare directives are made up of 4 documents. Most people do 3 or 2 of them, but I like to do all 4. The first one is healthcare surrogate. So these are naming someone to make healthcare decisions on your behalf if you can't make healthcare decisions. The living will, and I want to distinguish because some people mix them, the last will and testament, or the will is different from your living will. The living will says what you want, your wishes, if you are at an end of stage situation. So if you are in a vegetative stage, you want to be left on life support and so forth. That's the living will. The next is the HIPAA form, which allows your loved ones to get written and oral information about your health. And that's also a very important document. The last document that not too many attorneys do is called the pre-need document. And this is a very important document because let me just give you an example. If you have 3 children and you only want 2 of them, to be your agents, you say, child 1 can be my financial agent or take care of my healthcare needs, and then child 2, if child 1 cannot, but you don't want child 3 to be part of this for one reason or another. We don't know. And that's going to be your wish. Child 3 can technically, if you become incapacitated, they can go to court and try to get guardianship over you. Okay, so we live in the United States. Anybody can sue anybody for anything. Anybody can go to court and get guardianship for us to be our legal guardian. This pre-need document actually says, if that happens, these are the people that I want to be my guardians. So even if that 3rd child that you did not want to be involved in your finances to make decisions for you, even though you could love them, but maybe they're not good with money, or, you can have your own reasons why, doesn't matter why, you are saying to the court, if somebody goes to court and gets guardianship over me, I want these people, and you are very specific on who you want to be your guardian for your finances and your healthcare. So this actually is a really important document that I add in the estate planning as well. So we talked about guardians. I want to go into now the real reason we're creating an estate plan, okay? Estate planning is an act of love for our family members. It's also about self-care, and it's also about control, okay? To give us total assurance that everything is set in place. So I want to talk a little bit, why is it an act of love? How is it an act of love? And so I want to tell you a story. And this happened in my family. A relative of ours, a prominent doctor who was completely fine, dropped. He passed away very suddenly. He had a daughter in college who he supported. So he was paying for her apartment, he was paying for her books, her food, her car, her insurance, her tuition, and all of a sudden her father passed away. He did not have an estate plan in place. All his assets were frozen. And all of a sudden, this young woman who was 19 at the time, she had just started college, not only lost her father, but had no assets. She had a bank account, did not have enough to support her. All of a sudden, losing her father and losing like having no access to money she was completely distraught, where the family had to come in, give her money to support her until her insurance paid and until his assets were probated. So he had life insurance. People think, well, I have life insurance, they're going to just pay. Life insurance, by law, they have up to 6 months to pay because they do their due diligence. Not everyone's like, oh, here's a death certificate, pay me, they're going to pay. Most of the time they pay within 1 month. But I think it took about 6 weeks for the insurance to give her any money. But for 6 weeks, she had no money for food. And it's extremely painful to put our loved ones in that position. Okay, so definitely creating a heart-centered estate plan puts our loved ones in a really, it allows them to grieve without worrying about money, without worrying about what's going to happen to me. And this is such an important act of love for those for our family members. Next, it's about self-care. So another story, and I will be sharing a lot of stories, but because I think stories really hit home than me giving you all this legal jargon. Okay. So there was a situation where an elderly man, he retired in Florida, as many people do. His son lived in Colorado. And then he had a stepdaughter who lived in Florida, who would go to his house from time to time and cook for him and everything. He started forgetting things, and then all of a sudden, his stepdaughter started asking for his bank accounts and wanting to know things about, his money, and why don't you just let me help you with this? And he was feeling very uncomfortable. So he called his son and he said, I'm not feeling comfortable. Can you come? And what's going on? His son, yes, it was busy a little bit. And then he finally came to see his father, and they went to an attorney. His attorney suggested, he said, the best thing to do, let's do a guardianship over your dad so that you would be his legal guardian and make all decisions for it. They went to court, and apparently the son had filed bankruptcy 2 years before, and the judge didn't like that. So what happened is that the judge appointed a court-appointed guardian for the father and refused to allow his son to be guardians over him. Now, by the time this happened, the father was not well. He was in a nursing home. His son put him in a really good nursing home. He loved his father very much. And we had this, I wasn't the attorney. This was a story that was told to me by the attorney. His father, the judge refused to allow the son to be guardian because of that bankruptcy. The court-appointed guardian gets paid a lot to be a guardian. They get paid maybe, I think, maybe around $200 an hour. So it's a lot of money. So when the court-appointed guardian saw that the father was in a very good nursing home and that was expensive, he actually took him out, and he told the judge that, he doesn't have enough money for this nursing home. He was actually not preserving, he didn't care about the father. He was preserving the money for himself so that he could get paid as well. He took the father out, put him in another nursing home. The son was really upset, but he had no say because he was not his father's guardian. The story really took a turn. The son went to visit his dad. He took his dad for a walk, and he just couldn't bring him back to this really bad nursing home. He was so uncomfortable with this place that he took him in his car and he started driving. He's like, I'm taking my dad out of here. Eventually, nursing home realized dad is missing. They called the police. The police caught up with him, and he was charged with kidnapping his own father. So it's so important for our own self-care to name people who are going to take care of us, people that we trust, people that we love, people that we know that they're going to manage our assets in a good way, that they care about us before it goes to the judge, because the judge doesn't know anything. They don't know who this person is that gets getting guardianship over us. They're just making an educated guess according to what's in front of them, which is some paperwork. They don't really know the family dynamics. And then the last thing I want to talk about is control. So I had this woman call my office and tell me, I want you to, my dad is older. So what we did, instead of doing an estate plan, he just added me on all his assets. He's got rental properties, he's got his home, his bank accounts, all his assets. My name is on there. I want you to take my name off. So I said, okay, why? Like, what's going on? She's like, yeah, on all his rental properties and all the deeds, I just want to remove my name. And I said, why? So she said, my husband had a car accident. We're both on the insurance policy and he killed someone. And now they're going after my assets, and now they're going after my dad's assets because my name is on it. And it really broke my heart because unfortunately, I could not help her. I told her that if I would do this at this point when there's a lawsuit already and there's an accident that took place, it's a fraudulent transaction. Number one, I would get in trouble, she would get in trouble, and the court is going to unravel everything we're going to do anyway. It's too late. So her dad, who thought he was saving money to not do an estate plan and just add his daughter on everything, now has lost control over his assets, and they will be taken away from him because of this this really bad situation. So next I want to go into a little bit about probate, because again, people think it's like in the movies, everything is done in an attorney's office. It's not. Probate is filing a lawsuit against your assets, against your estate, really, so that creditors can know and get their money from you. Okay, it's not about taking care of your stuff or leaving a legacy for your loved ones. It's really for the benefit of creditors. It does take 3 to 6 months. A simple probate takes 3 months. It could take 6 months. It could take years as well. I know people that it's been in court for so many years because one family member is holding out and is not agreeing to things, and it's just making things difficult for the family. And it happens more often than you think. People are getting along, but once somebody passes, you see a side to people that you never knew before. There's also a lot of fees involved. So the court tells attorneys, because anything that involves court, okay, has complications. So there is a Florida law that tells attorneys how much to charge when they are involved in the probate, and it's approximately 3% of the estate, of the entire estate. So let's see what that looks like. Okay, so I just put out some numbers. So if you own a home, say it's a 500,000, rental properties, stocks and bonds, bank accounts, business interests. If you have an estate that's $1 million, the probate cost for attorney fees is $30,000. Plus there are court fees. Also, if you're most of the time with an estate like this, a CPA is involved. Someone has to see how much the business is worth. There's all sorts of other costs that are involved. So it really costs a lot more. So if you have an estate plan that's compared to the 3%, with an estate plan, sometimes it could cost the cost to administer a trust could be 0.5% or even less if your trustee is savvy enough to do most of the work. So it really depends on how much work the attorney will be doing. Other problems that can come up. So if a minor in Florida, under Florida law, if a minor is inheriting more than $15,000, even if their parents are alive, it has to go through the court, and the court monitors the money until that child is 18, and then the child gets everything outright. So imagine with me if a parent, so let's just give this scenario. Mom creates has a life insurance policy, $1 million policy, and she says 50% to my husband, and then 25% to child one, 25% to child two, and these children are minors, and mom dies. Even though dad is alive, if it's more than $15,000, he has to go to court to be able to manage the money, and the court oversees the money. And the court can come and say, why did you spend this money on this? And he's got to, every year, he's got to give him a ledger. So he spent, $100 on this, or gum, or bought them clothes. He's got to give a ledger of every penny that he used for their money and submit that to the court. There's also a lot of fees involved, and CPAs and so forth. And then when they're 18, they get the money outright. And we know 18 is a number. 18 is not a sign of maturity. Imagine having an 18-year-old who has, $200,000 or even more. What can that do for their life? I've seen young people in college who inherited $25,000, and he thought that was great. He dropped out of college, spent it all on his friends, and then he had to go back to school. He lost about 3 years of his life, and it was a mess because, again, 18 is only a number. It's not a sign of maturity. Also, not creating a heart-centered estate plan. I'm going to go a little bit deeper into what a heart-centered estate plan is. Assets can be lost. So how does an asset get lost? Right now in the Florida Department of Unclaimed Property, there's $2.9 billion. Yes, $1 billion. And most of that money belongs to people who passed away, and their loved ones did not know that they had assets in a bank account. Okay, so another example, somebody passes, their family doesn't know that they had a bank account, say with Bank of America, for $100,000 or so, and Bank of America doesn't know this person passed away. Their loved ones don't know to go to the bank and let them know that this person passed. And a couple of years pass by, maybe 2-3 years, and the bank sees there's no movement in this. So they may send a letter out to the last known address. By this time, nobody lives in the address, the home was sold, and nobody knows about this. So the bank gives it to the state. Okay. And people have no idea there was money left for them, for the family. So when I create an estate plan for my clients, we also create a ledger with all their assets on that ledger, so that if something happens to them, if they're incapacitated or they pass away, their successor, whoever they name to be their successor to take over, it's just a very easy process for them. Okay, so we talked about probate. We talked about how assets can be lost. We talked about people that, young people inheriting money at a very young age, and the money, gets misused. How do we create a heart-centered estate plan? So I want to give you this similarity. Imagine you decide to go to the supermarket and you say, okay, I don't want a shopping cart. I'm just going to carry everything in my arms. So you have your eggs, you have your bread, you have your milk, your soda, and you're carrying all these things in your arms. And all of a sudden you slip and fall. Everything flies in the air and goes on the ground, and it's spilled. And now we have a mess. We have a mess of all the things we had in our hands. Now, compare this to saying, okay, I'm going to go food shopping, but I'm going to take a cart, and I'm going to put my eggs, my milk, my soda, all my stuff inside this shopping cart. And you're pushing the shopping cart, and again, you slip and you fall. but all your stuff is in the shopping cart. They're protected. Whereas someone else can come and push the shopping cart for you and buy your stuff for you and take care of your stuff for you. This is similar to a trust, not just a trust, but a fully funded trust where you can, oops, let me go back. Okay, where you can put your assets in the trust. In order for a trust to work, it has to be fully funded. And this is a mistake a lot of people do. They go, and I've had a lot of people do this. They come to me to review their trust and they say, all my assets are in the name of the trust. I say, did you go and you actually open the bank account in the name of the trust? Did you retitle your assets in the name of the trust? And they say, no. Was I supposed to do that? I say, yes. Okay, in order for the trust to work, your assets need to be retitled in the name of the trust. So that way they're inside your trust. But if you don't, it's called funding your trust, funding your living trust. If you don't fund your trust, you have an empty trust and your assets are still going to go through probate. So this is a very, very important part. If you do have a trust, you need to make sure that you actually retitled your assets in the name of the trust. So I want to talk about traditional estate planning versus heart-centered estate planning. Traditional estate planning is about the documents. You go to an attorney and they say, what do you want? You say, oh, I want to leave everything for my spouse and my kids. They say, okay, let's do it. Here are your documents. Goodbye. Thank you. You're done. Without really going into the asking you questions. You don't know what you don't know. Okay. If you go in there and you say everything to my spouse, okay, great. Well, what happens if you pass away and your spouse remarries and you give everything to your spouse? Do you know that your spouse doesn't have to give anything to your children? They can give it to the new spouse. Are you okay with that? Do you want to change that? You don't know what you don't know. Okay, so there are so many other questions that you need to be asked so that you can make heart-centered decisions for your family and your loved ones. Okay, it's also one and done. So I have people come in and they say, oh, last time we created our estate plan was 10 years. And I say, do you know what's in your, they don't remember what they did. They don't remember what they wrote. They have no idea. Whereas heart-centered estate plan, every 3 years, I get together with my clients and say, does this plan still work for you? Let's look into it. Okay, let's make sure the people you name to take care of you are still in your life. Something really funny that I was reviewing one of my friend's estate plan, and I found that she named me as her guardian for her young children. Her children were grown. I said, well, thank you for letting me know. I had no idea I was in your estate plan. Whereas when I create an estate plan for my clients, I send a letter to the people they named, telling them what their duties are, what they need to do. It's so there's so much more to estate planning than just creating documents. Here you go, beautiful binder, just put it away and call it a day. Okay. Again, having no relationship. Once the documents are signed, you have no relationship with your attorney. Sometimes I ask the clients that are coming to me, we're redoing their plan, like, why did you do this? And they don't even know. They haven't reached out to their attorney for 10 years or so. So it's an ongoing relationship to support you and your loved ones. Again, money can go into probate, like creating a trust and never funding the trust, not even knowing that you're supposed to fund the trust. And assets wind up in probate anyway, even though you created an estate plan to avoid probate. Okay. And assets can be inherited by people you don't even know, like the situation with this woman who got sued and now her father's assets are in the lawsuit being taken by people he doesn't know, and he wasn't even responsible for this accident. Okay, so heart-centered estate plan, allows your family to have money immediately. Upon your passing, nothing needs to wait. There's no probate, assets are available for them. It's so important. So I'm going to share this with you. I recently lost my father, and his estate plan was so well done and so well organized that when this happened, I did not feel anxious. I wasn't distraught. I knew my mother was in a secure place. I knew there were funds available for her. It allowed me, I want to say it allowed me to grieve in peace. It allowed me to be creative when I was planning his funeral. I created a website so people can go on the website and share their memories of him. And after the funeral, everyone was telling me it was so dignified. And it gave me so much peace and satisfaction that I honored him. I was sad. I still am, in that state of pain and but I was there for my mom. When you lose a loved one, there's just so many emotions going on. You don't need to be anxious. I wasn't worried, oh God, now I have to go to court, or how is this going to be paid, or is my mom going to be supported? I recently had a friend telling me that when his father-in-law passed away, they discovered that all the assets were in his father-in-law's name, and his mother-in-law had no money. She had to sell the house. She couldn't afford anything, and probate took a very long time. It's so complicated. Imagine losing your husband and now losing your home and having to move in with your daughter, and just how horrible is that? It's enough that you lost someone that you love, and just to allow yourself to grieve, and then take care of things. And now, like, there's a lot to be done. I'm not saying there's no work to be done for my father's estate. We have to administer his estate, but I'm not in a hurry to do anything. I'm not worried about anything. I know things are going to go smoothly. So it really is an act of love for our loved ones to do this for them. And I'm not just talking, you could be thinking about yourself right now, to do an estate plan for yourself, but also if you have elderly parents, you need to be thinking about doing something for them, even gifting them this. You're not just gifting them this, you're doing it for yourself, because when the time comes, you don't want their mess to be your mess. Okay, so this is multi-level thinking as well. We're doing this for ourselves. I've had grandparents gift their kids this because their children didn't do anything, and they want to make sure if something happens to their children, their grandkids are secure and their guardians named for them, and all these planning is done for them as well. So again, heart-centered estate planning is so much different than just creating these documents that may or may not work for you. So where do we go from here? The first step is not just a regular consultation. So what I have done, I created this process to take you through don't want to call it a complicated estate planning, complicated. I created it in such a way where it's a step-by-step process that takes you lovingly and holding your hand through the process so that it's not overwhelming. Okay. And it starts with a life and legacy planning session. So I've created this planning session. It's a 2-hour session. And some of my clients take some individuals, they take a full hour, some only take an hour, but I like to allocate 2 hours because I don't like to rush people. I like them to think things through as well. During that meeting, you get financially organized. You're going to understand so much about your own estate plan. So today I gave you general look about estate planning, but we do a deep dive into your family dynamics, your assets, your wants, your aspirations, what keeps you up at night, what are you worried about? And during this meeting, you're going to understand what would have happened. What does it look like? The complete picture if you have passed away yesterday with the present plan. So if you don't have an estate plan, what does that look like? And then once you get a complete picture of what it would look like during that meeting, you could say, you know what, I'm okay with this, but I'm not okay with this. I want to change this. I want to do this. And we create a canvas of your, like a beautiful picture of what would happen if you became incapacitated, what would happen if you pass away, and your decisions for you. Okay. During this meeting, also, you will know exactly all the costs that are involved. Okay. I don't do hourly. Hourly is such a failed process because people are afraid to call me and ask questions because they know the clock is ticking and I'm charging them. So everything is based on a flat fee. Your questions are answered. I'm available for you as well. And there's no surprises whatsoever. Your family will, I'm there for you and your family. Okay. I'm not just, this is again, it's a lifetime relationship with you and your family moving forward. So, because you're here today and you really know a lot more than most people out there, only 30% of individuals have their estate plan in place. I want to give you two gifts. So the first gift is this life and legacy planning session, this 2-hour meeting with me. Is a gift for you. It's $750. I charge that because it's a strategy session about your life and what you want. And it gives you so much clarity to make informed decisions for you and your loved ones. The only thing that I require is that if we're doing estate planning for you and your spouse, that you are in this meeting together. If you're not there together, then I will charge for this, because if we're doing planning for the both of you, you both need to be in this meeting together so that you can both understand the situation. The second gift is that if you reserve your appointment today, you receive a $250 off of whatever estate plan, and I have different levels, whatever estate plan that you choose. So now we're going to get into the Q&A, but before we do that, I do want to explain something to you. There's a lot of people on this call, so there's no attorney-client privilege. So whatever question you ask, there's no privacy, and that's important. So if there's a specific question that needs privacy, then maybe maybe we can do this during the meeting or another time, but just understand that as well. This QR code is for you. It gets you into my calendar to book this meeting with me. Also in the chat, there should be a link for you to be able to go on and schedule. It will get you directly into my calendar. I am going to stop sharing now. And Daniel, I guess we can go into the Q&A.
All right. Well, thank you very much for that presentation. That was extremely informative. Hopefully everyone took a lot away from that. I know I did. I only have at the moment 3 questions sitting in the Q&A. So if anybody has questions you'd like to ask, now would be a good time to put them in the question and answer section of the Zoom. And I will have Dalia answer as many that we can get through. But for the time being, the first question is just, what is a durable power of attorney?
Okay, so there's a difference between a regular power of attorney and a durable power of attorney. A regular power of attorney ceases to work if you become incapacitated. A durable power of attorney, and it's very specific, has very specific language, especially in Florida. There's certain things that need to be in that document, allows it to work even if you become incapacitated. Someone, if you name them as your agent, can take the power of attorney to the bank and to sign checks, pay your bills. Just even if you have a brokerage account, manage all your assets with that document. It bypasses, even if you become incapacitated, it's not void, but it does cease to exist. It's void upon your passing. I hope that that answered your question.
Okay, what is the advantage of transfer on death as opposed to doing a lot of different documents?
So transfer on death I'm going to assume you're talking about a bank account, TOD or a POD. That's what they're called. You can put that in the account and the bank. It does avoid probate, but if that person, so for example, I say transfer on death to my husband after I pass. If my husband passes, it's going to go through probate. It doesn't allow things to pass from one generation to the other. It also, if I'm incapacitated, even though I put a transfer on death, that person I named cannot go into my account and pay my bills. My account, once I become incapacitated, my account is frozen. So it does not work for incapacity. It does work to keep things out of probate, but it also does not, there's no asset protection. So if I name my child, I have an adult child, and as transfer on death, and it goes into my son's name and my son inherits it outright and he's sued, that inherited money can be lost in the lawsuit. Like if he gets in a car accident, but if you create a trust and create a lifetime asset protection trust within that trust, then it shields it from his creditors as well. So with estate planning, there are so many creative ways that we can work to shield money from our children's creditors, from a failed marriage, from, if our spouse gets remarried. There's so many things we can do.
Okay. How would one title your individual condo?
So condos are interesting, okay? You'd have to look at the bylaws. It depends if this is your homestead. I haven't seen an issue in transferring the title into your trust and not losing homestead either, because there are laws in Florida that protect your homestead even if it's retitled in the name of your trust. If the condo is titled in your name and something happens to you, it's going to have to go to probate. Okay. And to avoid probate, you need to retitle it either in the name of your trust. There is also a different type of deeds called an enhanced life estate deed. Some people also know it as a ladybird deed. It has, these names to it, where you can say, upon my death, I transfer this asset to a specific person. It's like a transfer on death deed. But again, if that person dies that you named or incapacitated or involved in the lawsuit, that asset is also going to either go through probate or go through a lawsuit.
Okay. Next question. If you have a joint trust, can your spouse change that trust after you pass?
It depends. You can allow that or not allow it. So if you want to put some safety measures in there where upon your passing, assets in your name only that were transferred in the trust go to a separate trust, could be for the benefit of your spouse. So that question is, it really depends on what you want. We can create a trust to give everything to the spouse or not give everything to the spouse, and everything could split in a different sub-trust as well. So that's something that really depends on what you want.
Okay. What is required to set up a trust?
You come to me and we create a trust for you.
All right.
Yeah.
What if you don't do PRC codes?
What do you mean by what's a, I'm not familiar with a PRC code.
That's just what the question was.
Yeah, if you
Okay,
can clarify.
Next question. Aileen Burns, if you can if you may give us a little bit more on the PRC codes when you have a chance. I understand the difference between a pour over will and a will. The question is a will still required if you establish a revocable living will?
Yeah, a revocable living trust, you mean? Yes, a will is I do a pour over will. With a revocable living trust, I create a pour over will in case there's an asset that was left outside the trust that was not retitled in the name of the trust, or you acquired an asset after you established a trust and forgot to put it in the name of the trust. The pour over will is a very simple will that says, if an asset was found outside the trust, please pour it into my trust.
Okay.
Yeah.
Dalia, for your actual meetings, your planning meetings, can that be handled remotely for people who may not be here in Florida?
Okay, so it can be handled remotely, but I am licensed in Florida. So if you are a resident of a different state, I would not be able to create an estate plan for you because I'm not licensed. You know, I'm licensed also in New Jersey, but I am focused in Florida. But I'm licensed all over Florida. So the link that you received is for an in-person meeting. All you have to do is say that I want to do a virtual meeting in the notes, and then I will send you a Zoom link for that. So I practice all over Florida. I've done estate planning completely remotely. I have a notary, or a mobile notary, she's fantastic, and we work together very, very well. So yeah.
Okay. Can a law firm be named as an executor of an estate or a trust instead of an individual?
Yes and no. So for me, as if I'm doing your a trust, there's a law in Florida that I don't name myself as trustee, okay? Because people that beneficiaries can come and say undue influence and so forth. I like things to be separate. So if you want to name somebody else who is a law firm for your trustee, you can do that. And, you know, I've had people name their CPAs, certain financial advisors that they really trust as well.
Okay, this one's a little bit more in detail. It says, do you have any experience doing a trust for a special needs child? My mom has me as the executor of her trust and nothing in writing about having my brother move into an assisted living facility as he can't live alone. She will not put that in writing, so it's going to put me in a very uncomfortable situation. What options do I have, God forbid, when she passes?
I would need more information. This is a very detailed with the situation of her brother, what's going on right now, where he is. We would need to talk a little more. And with that, if you can you know, call my office and schedule a 15-minute call with me. You don't need to schedule an actual session with that. I would need more information, and my number is in the chat.
Perfect. And that would be
Okay.
the answer to the next question. Aileen, you had asked about the QR codes that was provided, or to sign up for, to have a call with Dalia.
Okay.
Just
Let me
give her a
share
call if
that
you can.
again.
Yeah, if you
Okay.
can't,
Let
you
me.
don't have the ability to use the QR code, you can send her an email at the email address below, and her phone
Right.
number is also in the chat. You can call her directly at the office.
Yeah, there's also a link. If you see the link, let me post it again. Copy.
Your calendar.
I'm what? Yeah.
Yeah, I got it.
Here.
You got
Oh,
it?
okay. Yep. I think it's
Perfect.
to the host and panelist. I don't know if you all got it.
Yeah,
Or
that's the host and panelists. Let me copy it
okay.
and see if
Can
I'll
you?
send it to everyone.
Yeah. And that's that link you can, again, when you click on that in the notes, please just indicate in person or on Zoom, and so that I can know what you prefer.
Okay, a couple more questions popped in. What is the average cost of legacy estate plan for a single person?
So it can start from 2,500 all the way to 8,000. It really depends on what you want. And this is what we establish during our meeting to give you all your options, and you get to choose, the level of planning that you want or need, or, but you make the decision from a very well-informed informed place.
Okay. I have a will written by myself. Will it become valid upon my death?
I don't know. Florida requires very specific things in a will for it to be valid. There's a self-proving and certain witnessing and notarization. So I really don't know what your will looks like, or is it created according to the Florida law? It really depends.
What is an irrevocable will or trust?
So an irrevocable will, an irrevocable trust. Upon your passing, your trust becomes irrevocable. So once somebody, while you're alive, your trust is really, you can do whatever you want. You can revoke it, you can change it, you can do so many things to it. But upon your passing, it becomes irrevocable so that nobody can change it and your wishes are honored. An irrevocable trust is just set and cannot be changed. Also, some people create irrevocable trusts while they're alive for specific asset protection and tax. It's mostly for asset protection. But understand, if you create an irrevocable trust for asset protection, you have no control. You relinquish control over your assets, and you have to
While you're
name
alive.
someone else, while you're alive. So this is a very tricky.
And so a revocable trust in turn would give you the ability to modify it while you're alive, but then upon your passing would become irrevocable.
Becomes irrevocable. It gets its own tax ID number, actually. Yeah, once you pass. It's like its own entity. Yeah.
Last question. Snowbird passes away in Florida. And does this need to go to probate in Florida, or can it be settled in the home state that they came from?
So where do they file? Where's their where are their resident? Where do they file their taxes? Okay, if they file their taxes, they're a Florida resident, and the probate needs to be in Florida. If they're in a different state, if they file the tax in a different state, probate needs to be there. But their assets in Florida, once the probate is filed in the state they're a resident of, you need to file another probate in Florida where the asset is as well. And that's the beauty of a trust. Sometimes you can, when you create a trust, you can retitle assets even in a different state in your revocable trust in Florida. Some people have homes in New York, New Jersey, and so forth.
Okay. Well, that takes us through all of the questions that I have. I think that's where we're going to wrap, Dalia.
Okay. Well, thank you so much.
Peggy?
Yes, okay, thank you so much. Great information. Even second time around, you pick up something, or at least I did. So thank you for that, Dalia, and thank you for
My
everybody
pleasure.
coming again. Thank you to you, Dalia, and also Daniel for moderating. The only thing I want to mention is there's a couple of webinars coming up that I'm going to have. One is in person. If you're in South Florida, you are welcome to come to a board certification training that's being held at the Environ Cultural Center this coming Monday, the 24th, from 5:30 to 9:30 p.m. So that is an in-person training by Jane Boland. And it's going to start actually at 4:30 with a little bit of a tabletop trade show with some sponsors. So if you're not on the list from me, if you don't know if you are, send me your email address to marketsmart01@gmail.com and I'll get you a flyer. On the 26th, we also have the Stratosphere series of roofing presentation coming, and that will be from 12 until 1:30. And then we go into March. Can you believe we're already going into March? It's crazy. But in March, we're also going to have several webinars that are lined up. One is from Vinteum software. If you don't know, the laws changed last year where any condominium association that has 25 units or more, you must have a website. And Vinteum, who is also my IT support, has the best website that you could use for a condominium. So I recommend you look for March 10th. It's a 12 to 1:30 webinar again. That's a Monday. And then the last one I want to mention is that we're going to have a board certification class on March 13th. That's virtual from 9 a.m. to 1 p.m. So March 13th from 9 a.m. to 1 p.m. And then I have some more coming on Sears and reserves and so on in March. So I just need to finalize the dates. But again, thank you so much for coming. I hope you connect with Dalia and get your answers and your appointments put together. She's very good, and I hope that all of you do the best for your families and your future. Thank you again. Bye-bye.
Very good.